Good afternoon, everyone. My name is Tripp VanderWal. I am a member of Miller Johnson's Employee Benefits and Executive Compensation Practice Group, and I am joined by my partner, Mary Bauman, and we are presenting today a webinar on no-fault reform. So for those of you that have been attending our daily COVID-19 webinars, this may be some welcome relief because other than kind of this introduction, we will not be addressing COVID-19. Now, having said that, if you did address our COVID-19 webinar this morning, you might be sick of Mary and I by now because we did that webinar as well. So maybe that's a good thing or a bad thing. I don't know.
Yeah.
But with that, we will move on into the substantive feature. Just some housekeeping items today. And again, if you have attended our COVID-19 webinars, you're probably aware of a lot of these. You can use the Q&A feature to ask questions during today's presentation. In the chat feature, there is a link to the slides that you can use to download. And we are recording today's webinar. And if you registered for today, whether you're able to attend or not, it will be emailed out to you tomorrow at some point, the link to the recording. Also, it will be posted on Miller Johnson's YouTube page, not our COVID-19 playlist, if you will, but it will be on Miller Johnson's YouTube page. Next slide, please. There we go. So I think kind of to introduce this, this is Mary and I's second webinar on no-fault reform, and I know that she and I have both done other presentations on this, so many of you are probably aware or somewhat aware of the changes, but I would say the biggest aspect that we are going to address in this webinar is the differences in PIP medical benefits. And so before no-fault reform, owners or registrants of a motor vehicle were required by Michigan law to purchase a no-fault policy with unlimited personal protection insurance, which they call PIP, which included PIP medical benefits. After no-fault reform, specifically for no-fault policies that are renewed after July 1, not on or after, so no-fault policies that are renewed beginning July 2, owners or registrants of a motor vehicle are no longer required to elect unlimited PIP medical benefits. They may elect various lower levels of PIP medical benefits, or in some situations may be able to exclude or opt out of those PIP medical benefits entirely. So I guess to kind of tell you where this webinar is going, we are first going to kind of explain the differences between PIP coverage and coverage under your garden variety or typical group health plan, similarities, differences, explain that because of no-fault reform, particularly with self-funded group health plans, the ability for individuals to elect lower levels of PIP medical benefits or opt out may shift more expenses to your self-funded group health plan in the event that your participant is in an automobile accident. And then we will also explain kind of the coordination rules between group health plan coverages and no-fault benefits, and explain how we can make plan design changes to minimize or totally, or in a sense, totally eliminate that shift in expenses.
And what we have to do about communicating to employees.
Exactly. And then we will address some next steps. So we do have a pretty full agenda today, and we did get a number of questions before our webinar, and we think a good portion of those will be addressed in the content of this webinar. And we will try to address some at the end, maybe that we didn't get to, but I don't think we will have time today to cover everything. Next slide, please. Next slide. So what is PIP? So personal protection insurance, PIP, is a component that you purchase under a typical Michigan no-fault insurance policy. And PIP actually has three components. One is PIP medical benefits, which pays for all reasonable charges incurred for reasonable and necessary products and services and accommodation for an injured person's care, recovery, or rehabilitation as a result of an auto accident. PIP also has a component that includes wage loss. So for 3 years, participants may be able to, the no-fault policy may pay lost wages to a participant up to a certain percentage. And then finally, there's a third but smaller component of PIP that is replacement services, where participants can be eligible, injured individuals can be eligible for up to $20 a day to pay for certain services in their home that they are no longer able to do because of their automobile accident injury.
Right.
And one thing,
so cleaning or a personal attendant to help them
yes.
bathe or dress or those kind, cook. Those
kind of non-medical services, exactly.
Right. Right.
And one thing that I'm going to highlight at the beginning, but that we will be touching on throughout this webinar, is if someone is eligible to waive or exclude PIP coverage, and we will explain what the difference between waive and exclude means, it appears that the waiver exclusion only applies to PIP medical benefits, meaning that an individual who waives or excludes it still appears to be entitled to wage loss and the replacement services component. And why I say it appears, it's a little bit uncertain, right, because everything in the application that we've seen from the Department of Insurance and Financial Services is very explicit, and it talks about only an exclusion or a waiver of PIP medical benefits. But actually the no-fault reform statute said the whole PIP premium has to be reduced to zero in a
right,
waiver and exclusion circumstance. So it actually appears the way that the law has been interpreting right now, if I waive or exclude PIP, even though I'm not going to pay a premium, I may still be entitled to wage loss and replacement
right,
services.
Which is very relevant for employers, for example, with short-term disability benefits. And if you exclude due to an auto accident, hopefully that means that the person will still get sufficient wage loss benefits through PIP.
Exactly. Next slide, please, Jeff. So there are a number of medical items or services that are covered by PIP medical benefits that are covered by your typical employer group health plan. You can see examples: hospitalization, surgery, prescription drugs, various tests. I don't need to read through all of those, but those are common medical items or services that are generally covered by PIP and an employer group health plan. Next slide, please. However, PIP is going to cover a lot more than a typical group health plan. And here, again, is just some examples. This is by no means an exhaustive list. So inpatient skilled nursing, which may be covered by a group health plan, but PIP is usually going to cover it beyond the usual time limits. So, for example, past the point of rehabilitation or recovery. Physical speech, so PT, ST, and OT, attendant care and nursing services. And then I think other big ones are home and auto modification. So if you need a ramp to get into your house because you're now wheelchair bound, or if you need a modification to help get you in and out and operate your automobile, those are things that will be covered by PIP, but are not likely to be covered by a typical group health plan. So I think the main point of the last two slides is to really emphasize or drive home the point that, PIP benefits are generally much more generous than the benefits under a typical group health plan. Next slide, please. So again, and I alluded to this on my first slide, is under no-fault reform, beginning with policies issued or renewed after July 1. So in other words, those policies issued or renewed on July 2, Michigan drivers can continue to purchase unlimited PIP medical benefits. And there are a number of reasons that individuals may want to do that, specifically because of those PIP benefits being so more generous. Alternatively, individuals may be able to elect a lesser level of PIP medical benefits, or again, either waive or exclude benefits. And again, the rationale behind this change was because no-fault premiums in Michigan were so high, and I think it was actually the highest of any state in the country, allowing people to elect a lesser level or even opt out of PIP medical benefits will hopefully reduce those no-fault policy premiums. Next slide, please.
So Tripp, in terms of your no-fault policy, how does everybody renew on the same cycle, or how does that work?
No, so there is going to be staggered renewals. So typically in Michigan, I believe renewals are every 6 months. So using myself, for example, we just renewed February 1st. So our next renewal will not actually be until August 1st. So I, again, using myself as an example, wouldn't be able to elect something other than unlimited PIP until August 1st of 2020. So these options are going to present themselves, these options to elect other levels of PIP medical benefits will present themselves to individuals at different times throughout the next 12 months.
Right, right. And we'll talk a little bit more about the kind of this effective date in terms of implementing some of these options a little bit later. Okay, so now we're turning to what the medical benefit options are under PIP, beginning again for policies renewed on or after July 2. As currently is the case, you can carry an unlimited amount of PIP medical benefits. Option number 2, you can carry $500,000 in PIP medical benefits per accident per person, or option 3, $250,000 in medical benefits per person per accident. Those first 3 options are available to all Michigan drivers. And so, I kind of look at the 250 as the kind of base or basic option. And now we have some options that are only available to certain people. Option number 4, for drivers who are enrolled in Medicaid, not Medicare, but Medicaid, which is governmental health coverage for lower income individuals, they may elect $50,000 in medical PIP benefits because they're going to be getting coverage through Medicaid, provided that the other members of their household are also enrolled in Medicaid, or they're enrolled in qualified health coverage. We're going to define that in a moment, or they have at least $250,000 in PIP medical through another policy. Next slide, please. So those are the first 4 options, and then here's options number 5 and number 6. And you may say, they seem kind of similar, and they do. These are the 2 what I call opt-out options, but they're different. So the first option is to exclude. So if I am a driver who is enrolled in qualified health coverage, except if my qualified health coverage is Medicare Parts A and B, and again, I'm going to define that in a moment, I can elect to exclude PIP medical for myself, and also I can elect to exclude PIP medical for any other member of my household. I do this on an individual by individual basis, provided that that person is enrolled in Medicare or other qualified health coverage. So this is done on a person-by-person basis, and you will see that there have been some forms issued to help insurance agents and insurance no-fault carriers walk through these options with individuals, and that will help you identify this option and then identify the people that are going to have PIP medical excluded. Then the last option is for someone who is enrolled in a driver who's enrolled in Medicare. And remember, I enroll in Medicare due to my age 65 or older, disability, or if I have end-stage renal disease, which is permanent kidney failure. I'm eligible for Medicare. If I'm enrolled in Medicare and then all the other members of my household either have Medicare, other qualified health coverage, or at least $250,000 in PIP medical through another policy, we can waive PIP medical. But in this option, the waiver applies to the whole household. It's all or nothing. So we can exclude the driver and identified members of the household individually under the first option, the exclusion option, and the second, the waiver option, applies to us all as a family. Next slide, please. So then you may be wondering, what is qualified health coverage? Qualified health coverage is either Medicare, and that's where I enroll in both Parts A, which is hospitalization, and Part B, which is things like doctor's visits. And the other form of qualified health coverage is employer group health coverage. But employer group health coverage can only be qualified health coverage if it satisfies two requirements. One, the annual deductible per individual is $6,000 or less. And number two, the plan does not exclude or limit coverage for motor vehicle accidents. And boy, oh boy, Tripp, do I sure wish that the state legislature had better defined these terms when it crafted the legislation, don't you?
Yes, because there's a lot of questions here. Specifically, I would say with respect to kind of, I would say almost more so with respect to the $6,000 deductible.
Yeah.
You know, we got a very interesting question before the webinar that I think we might as well address now is, what if my group health policy has, a deductible that is above $6,000 per individual, but I make HSA health savings account or HRA contributions, employer contributions on behalf of those individuals, which will essentially reimburse those individuals for their out-of-pocket expenses and will bring them down below $6,000. Can that bring an otherwise health plan that is otherwise not qualified health coverage into being qualified health coverage? And I would say at this point, Marion, I think you agree, we don't know the answer to that. I think with respect to HSA contributions, those are absolutely not going to be included. With respect to HRA contributions, I think the answer is a little bit less clear, but I would say absent any other guidance at this point, to say that an HRA will bring non-qualified health coverage into being qualified health coverage is an aggressive interpretation.
Right. And then, of course, the other, kind of big question that a lot of employers asked when this came out was, if I pay secondary under my employer group health plan, I'm self-funded, to no fault, is that an exclusion or limitation which would take me out of the qualified health coverage definition? And while the state of Michigan has not been as affirmative and specific as I would like, it appears that their position is a secondary provision is not an exclusion or limitation for this purpose. So if you offer secondary coverage under your employer group health plan to Medicare, it would appear that you could still constitute qualified health coverage for this purpose. Next slide, please.
And I think the way that we kind of wrap our heads around that, Mary, is that a secondary provision, if there is no other primary payer, the secondary payer is going to step into the shoes of the primary payer and pay Correct. On a primary basis.
And so that's why it's not an exclusion or limitation for this purpose. Correct. Okay, next slide, please, Jeff. So just kind of wrapping up this segment, as Tripp has already mentioned, PIP Medical covers many types of expenses that are not covered under an employer group health plan, particularly those beyond any limits or restrictions in the plan. Jeff, next slide.
And Jeff, you can move right on to the next slide. So before we kind of move into different plan design decisions for self-funded plans, I think it's important to understand how the coordination rules apply between no-fault policies and group health policies, because those coordination provisions didn't actually change. What changed, of course, is the individual's ability to maybe elect a lesser or no PIP medical benefits, which again may potentially shift more cost or expense to a group health plan. So before no-fault reform, individuals were basically able to buy two types of no-fault policies, and one was an uncoordinated policy. So this was a no-fault policy that was more expensive because it paid primary it paid medical expenses primary, regardless of an individual's other coverage. The other type of policy was called a coordinated policy. And the benefit of a coordinated policy is that the premium was less expensive to the individual because a coordinated policy was basically allowed it to coordinate and pay secondary to an individual's other group health coverage if possible. Next slide, Jeff. So as you will see here, if a no-fault reform, for fully insured group health plans, there is a Michigan Supreme Court's case that basically said fully insured group health plans have to pay primary to no-fault policies. Otherwise, we can't give effect to the reduced coordination, the reduced premium for the coordination. So fully insured group health plans were always required to pay primary, and will still be required to pay primary to no-fault policies. But if you're covered under a self-insured or self-funded group health plan, that plan may have a coordination provision with an attempt to pay on a secondary or even exclude benefits in the event of auto accidents. And so typically here, there was some concern if that, if I ran out to my auto no-fault agent and said, oh yes, I'm enrolled in my employer's group health plan, and really no other questions were asked, and I didn't understand that, my plan that was administered by a, Priority Health or Blue Cross Blue Shield of Michigan and very much looked to me like it was a fully insured policy. I said, oh yeah, I have coverage through my employer's group health policy, and I didn't know that it coordinated benefits with no-fault policies. What happens if I bought this coordinated policy and got a reduced premium? Well, the penalty was really not that severe. There was usually a deductible or a penalty imposed in the event of a no-fault accident, or I'm sorry, an auto accident, where the individual had to pay either a $250 or $500 deductible, and then the no-fault carrier would step in and pay primary. Next slide, please, Jeff. Self-funded group health plans, however, unlike fully insured, which are legally required to pay on pay primary to no-fault policies, are not subject to that rule to the extent the self-funded group health plan is sponsored by an employer that's subject to ERISA. And the way we get there is generally as ERISA is thought to preempt state law, and that would include this law that requires a group health plan to pay primary. So sponsors of self-funded group health plans had some plan design decisions, and I would say typically those plan design decisions were typically a self-funded group health plan would pay secondary to a no-fault policy. And even though there was a secondary provision there, Mary, I think since everybody used to be required to carry unlimited PIP medical benefits, it was very, very rare that a group health plan actually had to come to the table to pay any expenses in the event of a no-fault or in the event of an auto accident, because it was all covered by the no-fault policy. In some group health plans, because of those very, very generous PIP medical benefits, decided to exclude benefits entirely in the event of an auto accident. Next slide, Jeff. But we also have self-funded group health plans that may be sponsored by employers that are not subject to ERISA, specifically church and non-federal governmental employers. And since those are still self-funded plans, it's a little bit less clear, but they're not subject to ERISA. I would say kind of the conservative position would be that they were not entitled to pay secondary, because that would violate the Michigan law that required group health plans to pay on a primary basis. It did appear, though, that these self-funded group health plans could totally exclude benefits in the event of an auto accident. And again, I think the idea behind that, Mary, was that a total exclusion is not a conflicting coordination clause. It's just saying we don't cover this, so there is no primary payer, so no fault has to come in and pay as if it was primary.
Right.
And so, and if a no-fault ERISA employer, non-ERISA employer's group health plan paid primary, typically you'd want to make sure that you had strong subrogation and reimbursement provisions that potentially allowed you to recover any of the expenses paid by a third party involved in the accident. So was your participant injured in an auto accident that wasn't your participant's fault, and would that allow you to go after, for example, the insurer of the at-fault driver? Next slide, please. So clearly, I would say Michigan no-fault policies have been unique because most other states did not have this requirement that you carried unlimited no-fault unlimited PIP medical benefits. So for those employers out there that operated in many states, I think what you would generally see, Mary, is to not allow the people that didn't live in Michigan to be basically uninsured for auto accidents. Is for any Michigan residents, the self-funded group health plan would either exclude or pay secondary for Michigan residents, but would only pay, but would also pay secondary for non-Michigan residents.
Right.
And for those non-Michigan residents that had a very minor level of PIP medical or minor level of medical benefits under their no-fault policy, in those situations, the group health plan may have to come to the table and pay.
Right. Yeah. So just to give you an idea, folks on the call, we're talking somewhere in the $5,000, $10,000, $20,000 range of required medical coverage under auto policies in other states. I think New York has $50,000 of required coverage, but nobody even comes close to requiring the PIP medical that Michigan requires. Okay, Tripp. Well, I might as well be in full disclosure here, guys. It looks like my Wi-Fi, my home Wi-Fi is down. So, Jeff, I'm just going to say next slide as necessary here, and trust that you will migrate us forward. But now we're going to look at what your options are for as an employer group health plan sponsor. Next slide, please. So, as Tripp already mentioned, because of Michigan law, if you're fully insured, you have to pay primary. You really don't have any choice. But if you're self-funded, you do have choices with some restrictions if you're non-ERISA. But your first choice would be to pay primary, just like a fully insured plan would. And as long as the deductible under your plan doesn't exceed $6,000 per person, that's going to mean that you offer qualified health coverage, which will allow participants to elect one of those two PIP opt-outs, exclude or waive, for anyone that's covered by that group health plan. And so obviously this is going to cause the maximum exposure for the employer group health plan because it will pay first in the event of an auto accident. Option number 2, next slide please, is to exclude coverage. And of course, under current PIP, which is unlimited, this will always make, basically people will have adequate medical coverage. But an exclusion is not qualified coverage. As a result, the participant is going to have to buy at least $250,000 of PIP medical. And the question then becomes, if I am an individual that I elect the $250,000 or $500,000 PIP medical option, and I'm uninsured under my employer group health plan, once I reach that limit, I'm not going to have any coverage at all. Tripp, I know we've talked to some of our ERISA litigators at the firm who have, a lot of familiarity with auto accidents. What do they say about what the typical costs are, medical costs are associated with an auto accident?
Well, I think, kind of a rough estimate is that $250,000 will cover most of the necessary medical expenses in the event of a high percentage of auto accidents. The problem, of course, is those catastrophic accidents where you may have a lifetime of medical needs, whether it be attendant care or be completely disabled. And in those are the situations where you could very easily exhaust both the $250,000 limit
right.
Or the $500,000 limit.
Right. So these first two options that we've just mentioned are available to both ERISA and non-ERISA self-funded employer group health plans. Next slide, please. Option number 3, paying secondary. This is not available to a non-ERISA self-funded group health plan, but it is available to an ERISA self-funded plan. Now, prior to no fault, as Tripp has already mentioned, the plan would rarely be required to pay because PIP would step in and basically pay everything. But now, in this situation, as we've already alluded to, a secondary COB provision will not disqualify the employer group health plan from being qualified health coverage. So the employee could potentially elect to waive or exclude PIP medical, which again may essentially cause the employer group health plan to pay primary. We don't know how many employees are going to elect the waiver or exclusion options, but this is a reality. Next slide, please. And then option 4, which we also do not believe is available to non-ERISA plans, self-funded plans, is to exclude the first $250,000 or $500,000 of claims in the event of an accident, and this will cause the plan to lose its qualified health coverage status. As a result, the participant will be required to purchase at least $250,000 in PIP medical. Tripp, when we've talked to employers, I think most of them are gravitating toward the $250,000 as opposed to the $500,000. Would you agree on that?
I would agree. I'm not aware of anyone that has elected the $500,000 level.
Yeah.
Again, I think for two reasons. One is because, $250,000 is going to cover almost, all of the necessary medical expenses and a vast majority of auto accidents. But also, if I'm requiring my employees to buy $500,000 of coverage, they're going to pay an increased no-fault premium.
Right.
Compared to $250,000. What that increase is, nobody knows at this point. But I think they do that for employee morale, if you will.
Right. So then after that $250,000 or perhaps $500,000 exclusion, your plan would pay on a secondary basis to any no-fault coverage the person might have. Probably unlikely that they'll have any coverage, but that's typically how this option would be structured. Now, we understand that there are several TPAs, third-party administrators, who have, here in Michigan, who have agreed to this option 4, which is a little bit out of the box, but we're hearing most TPAs will handle this. But there is one notable exception of an administrator that is resisting this, and Tripp, I think we could probably disclose who that is.
Yeah, go for it.
So Blue Cross, who obviously is, an insurer for self-funded, for fully insured plans, is paying primary for those plans. But for self-funded plans, it has expressed resistance to this approach because of its concerns about how to go about administering it. So it's not saying that it's illegal. It's not saying that it's impossible, but it has been putting up its hand and saying, I'm not sure I can do this. So just want you to be aware of this. So if you are considering this option, you're going to want to check with your third-party administrator as soon as possible to make sure that they can accommodate this. Next slide, please.
So before we move on to the next slide, I think maybe one thing to point out, though, is I think some of the third-party administrators are simply trying to figure out at the current point how they are going to administer a $250,000 or a $500,000 exclusion, because I think that's a little bit unclear and there's some difficulties there. Yeah.
So it's not. We're not saying that it's an illegitimate position. We're just saying that this is what we've experienced so far. Okay. I don't know if you've advanced the slide or not, but I'm moving on to the next slide. So one consideration is, should we consider 250 or 500 if we're going to go with this option? I think we've already kind of talked about what the typical claims costs are. Most of our clients looking at this option are gravitating toward the 250. And then also just be aware that if you do go with, let's say, a 250 exclusion, paying secondary thereafter, I should say, there may be an increase in your subrogation activity. In other words, if you do pay claims, let's say in excess of $250, you may be seeking reimbursement from a third party or its insurer if a third party contributed to the cause of the accident. So just want you to be aware of that. And so if that's the case, you want to make sure that you have looked at the subrogation language in your plan to make sure it's strong. You want to make sure that you also may have, thought about getting legal counsel in place to make sure that you can pursue those rights. Next slide, please. Another issue that we want to bring to your attention about this option 4 is that there is a rule under the Affordable Care Act which requires non-grandfathered group health plans, that almost all health plans are non-grandfathered right now, that they can't impose an out-of-pocket limit, which includes deductibles and copays, over a certain annual amount. And if this exclusion was recharacterized as a deductible, then this design would in fact violate the ACA prohibition on maximum out-of-pocket limits. This hasn't been decided yet, Tripp, but I think it's an argument, and it's certainly one to bring to your attention. And, depending on how risk-averse you are, because the penalty is serious for noncompliance. $100 per day per person.
I think, but I think, to say this is a deductible is really, I think, an aggressive interpretation, because to me it just doesn't in line with the fact that, okay, it would be totally permissible for me to exclude these benefits entirely, but to provide coverage for them only after 250 is a violation. So to me, it doesn't make a lot of logical sense, but as you know, Mary, the Department of Labor and the IRS is not always logical in their interpretations of things.
That's correct. That's correct. I would say I've seen a couple different people raise this issue in commentary, but certainly nothing that has been raised from, the government or in a court case or anything like that. And we've already talked about the fact that you need to be ready to pursue subrogation actions if possible, if potentially available. And then also remember that if you do operate in other states, you're likely going to want to keep a secondary provision in those other states because of the inadequacy of medical coverage under auto policies in those other states. But again, if there's a third party involved in the auto accident that caused the need for you to pay expenses, you can certainly ask that third party or its insurer to reimburse you for the benefits that you have paid, whether you ask nicely or have to eventually sue them. Okay, next
Mary,
slide.
just to interject one thing here, because we did get an interesting question or statement on the Q&A. It was an employer that had operations in a number of different states, and we're wanting to make sure that he understood this correctly, and I think he did. Is my understanding is if I pay primary or secondary for cost savings for my self-funded plan, that's really going to be irrelevant because I'm ultimately going to have to pay primary in any situation. Even if I adopt a secondary provision, I'm going to pay primary in any situation where an individual elects no fault benefits. And I'm not going to, or if I do the $50,000 or $250,000 or $500,000 exclusion, I'm only going to realize that with respect to my employees who are Michigan residents. And absolutely. So if most of if you adopt a $250,000 or $500,000 exclusion, that's really not going to show up in any cost savings to your non-Michigan residents.
Right. Correct. Which also brings up kind of another, I think, interesting question that we had submitted ahead of time, Tripp, and that was kind of talking about the timing of all this. So, obviously, probably a good majority of you are operating your plans on a calendar year basis. So you might say, well, gee, Mary, when do I adopt a change here? If I was interested in option 4, when would I adopt a change here? Well, you could adopt the change as of July 1. Or you could say, maybe I'll, wait until January 1. You could do that too. Well, Tripp, if I wait till January 1, and let's say I'm paying secondary now, anybody with unlimited PIP, I'm still going to be paying secondary on. But by January 1, almost everyone will have renewed their policies, and some of them may have potentially by that time elected to waive or exclude PIP medical.
Yeah, so you could incur additional expenses relative to auto accidents between,
Right.
basically July 2 and January 1. And I did get a helpful comment from one of our audience members who is much more familiar with no-fault policies and had indicated that even though mine renews every 6 months, that a majority of no-fault policies renew every 12 months, but there's a lot of no-fault carriers that are offering, from what I understand, mid-year renewals after, beginning January 2 to allow people to elect
Right.
into these
Right.
other PIP medical benefit options sooner than what their typical renewal would be.
Right, right. So, that's just, and then one other question that we've kind of had before, had submitted ahead of time, this kind of relates to, so what if I'm, for example, I elect to waive or exclude PIP medical? And then, because I think my employer has qualified health coverage, and then let's say I switch jobs, or at open enrollment, my employer switches its plan design, and so it doesn't have qualified health coverage anymore. What do I do? If I lose qualified health coverage, Tripp, am I, in deep trouble here, or what happens to me?
So if you are enrolled in qualified health coverage and you lose it, you have 30 days to enroll in PIP medical benefits and have it be effective of at least $250,000. If you are injured in a no-fault accident within those 30 days, you are actually eligible for at least $250,000 of medical benefits under the MACPA, which is the Michigan Assigned Claims Plan. But if you don't secure that coverage within 30 days, and that's not just requested or work with your agent to get it in place, it has to be in place within 30 days, and you get in an accident and you had previously waived coverage because you were in qualified health coverage, there's no medical benefits for you.
Yep. And I think that, one of the issues that employers have to think about here is if I exclude either entirely or I exclude, let's say, the first 250, and my employees innocently or intentionally don't buy any PIP, they're not going to have coverage unless they fall into this narrow window of losing qualified health coverage and having the 30 days to elect. Otherwise, Tripp, they have no coverage, and then how does the employer feel when they get into an auto accident that they're not going to have any coverage? Because if the employer pays at that point, it's not covered by a stop-loss carrier.
Correct. So it would be, exactly, it'd be payments completely out of the employer's pocket with no benefit
right.
of stop-loss protection. We
right.
did get an interesting question, Mary, and this is probably a good one for you. Now that we've gone through the 4 different kind of plan design options for self-funded ERISA plans, are you seeing any trend into which option a typical employer with a self-funded ERISA plan is picking?
Well, I can tell you that there's not that many employers interested in secondary anymore, and if they are secondary, I think they're looking at it as I'm going to stay secondary, but I'm going to watch and wait, see how my employees react, how many of them elect to waive or exclude. So being secondary, I would say, is kind of a temporary watch and wait type option. I do have some clients that are going with either staying with an exclusion or keeping their exclusion, particularly those employers that have an exclusion right now. I do feel like they feel like if I just do a good job of communicating the importance of getting adequate PIP medical, that's an option. But I would say, Tripp, a lot of our clients are looking at option 4 of okay. excluding the first 250. That would be,
and that would be the 250
feeling.
exclusion, not the 500. Yep.
Right, right. Okay, again, I apologize that my internet is out. Jeff, I am on the next steps portion of the PowerPoint and the first slide there under next steps. One of the things that many of you are aware of, and it's probably because you've been notified by your insurance agent, maybe your insurance company, maybe your third-party administrator, is that you should be notifying employees about whether your coverage is qualified health coverage. I would say this is part of a bigger strategy. For me, if I'm an employer, I'm thinking about, as a service to my employees, I should be sharing with them information about no-fault reform. Also, I think it might be a good idea for me to educate my employees about the advantages of PIP Medical, right? I mean, PIP Medical, as Tripp has illustrated beautifully, covers way more than my group health plan. And also, Tripp, I think we might have had a little slide issue at this point in the presentation where we also wanted to emphasize PIP benefits last a lifetime, subject to any coverage limits. So if I elect PIP Unlimited, I'm going to get coverage for anything I need relating to my auto accident for the rest of my life. But if I'm covered under a group health plan, I only am covered while I'm enrolled, which is going to end upon termination of employment plus probably COBRA, right? That's it. So,
exactly.
So the duration of PIP and the comprehensiveness of PIP make it very, very desirable. And so, you know, communicating that to your employees, and then finally communicating to your employees whether your coverage is qualified health coverage, because that will give them the information they need to decide which of the options are available to them. And so back earlier this year, DIFAS, which is the Michigan Department of Insurance and Financial Services, which regulates insurance, issued a bulletin, and it said health insurers and health plans should, didn't say must, it said should, develop a document that indicates whether a person's coverage is qualified health coverage. Next slide, please. And in this communication, in this bulletin, DIFAS said, hey, to be compliant with this bulletin, we think you should disclose in an individualized letter the participant or policyholder's name and all the people in their family that are covered under their policy and their date of birth, and then a statement as to whether their coverage is qualified health coverage or not. Now, Tripp, fully insured plans obviously are subject to regulation by the state of Michigan through you know, the insurance laws, but self-funded plans, Tripp, you know, I don't know what the enforcement authority is for them to require employer group health plans that are self-funded to provide this notice.
I agree. I don't think there is any enforcement authority that the Department of Insurance and Financial Services has over a self-funded plan, but I think it's certainly wise for a plan sponsor to communicate this information so that employees are making the right decision, especially if you're adopting a plan design of $250,000 exclusion, so people don't inadvertently waive PIP benefits and have a $250,000 coverage gap. But they probably don't need to follow these steps or these requirements that DIFAS has set out for a notice. We could probably be much more robust, if you will, to prevent follow-up questions, or to at least to weed out some of the questions that we could easily weed out. And going back to your notification requirement, even if you sponsor a fully insured plan that's qualified health coverage, and you really don't have any plan design options, I've gotten a number of these questions filter in here, Mary. Is it still worthwhile to buy unlimited PIP? And I think, as we explained, because of what PIP covers and it goes on for life, it absolutely. If you can afford it, is worthwhile to consider. And we may, even as an employer of a fully insured plan, want to make sure that our employees understand that. And so we'll continue to buy unlimited PIP if they can afford to do that.
But I do want to say, self-funded employers on the call today, if so, you probably are going to say, yeah, you're right, Tripp and Mary, employee communication about a lot of this stuff is good. But do I really need an individualized letter with people's names and the names and dates of birth of their family members that are enrolled? And I would say absolutely not. If you want to just do a general communication that you provide to everybody generally without going through that work, I think that is totally defensible for a self-funded plan. Really do. And then, finally, as we've already discussed, making sure that you understand that after no-fault reform takes effect, if your plan does pay benefits, whether it's in Michigan or whether it's in other states where you have employees, and there's a third party involved in that accident, remember, you can always pursue what we call subrogation and reimbursement against that person and or its insurance carrier to be reimbursed for any expenses that the plan pays. And if you're going to do that, you need plan language, you need an attorney or somebody set up a subrogation firm to help you pursue those and pursue them promptly in the event those circumstances arise. So, Tripp, with that, I think I'm going to turn it back over to you and see if we have any questions.
So I don't know if you've probably, and I apologize for this, heard some typing in the background. That has been me busily trying to answer some of the Q&As that have come in over our Q&A feature. But there are a couple requirements or a couple questions that I think are good. And the first one relates to qualified health plan coverage. And it is, does the $6,000 deductible per person assume in-network or out-of-network benefits for plans that have in-network or out-of-network plan designs?
To me, this again is not answered, but either in the statute or any guidance that we've had. But I think I would argue that if the in-network is no more than $6,000, it's qualified health coverage. I don't know, Tripp, what do you think?
I agree with you, and at this point, but at this point, I think maybe the conservative answer would be consider both. But I agree with you. I think in-network is probably sufficient.
Yeah. I know somebody did ask in advance, Tripp. Miller Johnson has we have a couple people at Miller Johnson that know no fault like the back of their hand, and in the past we have put out a little booklet that beautifully summarizes no fault. And I can tell you that some of our colleagues are in the process of updating that booklet. And so we will be making that available in the future. And I'm sure when we do, we'll be putting something out on our website about the availability of that.
Wonderful. So another question, again, on qualified health coverage is your reference to deductible truly the deductible and not the annual out-of-pocket max that would include coinsurance premiums and coinsurance and copayment amounts? Again, I think that's unclear at this point, but a strict reading of the statute would say it has to, I would say, just deductible at this point. I mean, it uses the term deductible, not participant cost sharing.
Yeah, I agree.
Another question, Mary, that I think is a good one is, what are the communication requirements for self-funded non-ERISA plans? Because arguably, as we explained in the beginning of this presentation, self-funded non-ERISA plans don't benefit from ERISA preemption. So do they have to provide these notices that the insurance companies are required to provide?
Well, I mean, I guess what I would say is, this notice, this bulletin says health plans and health, insurers, and it doesn't distinguish. I would also say that, we don't have ERISA preemption to save a non-ERISA governmental plan from state regulation. So, I think to me, if I'm a governmental plan, I would think I would want to communicate to participants. I don't know.
In accordance with the DIFAS requirements?
Yeah, you know, I mean, at this point, what is DICE going to do, really, Tripp? You know?
Well, and if we make a
know.
robust communication but don't include necessarily all of the covered participants, I see that as kind of a no harm, no foul, because a typical employee is going to know who in their family is covered, and if it's going to be qualified health coverage for one individual, it's going to be qualified health coverage for everyone.
Yeah, I know. I agree.
So let's see here. Bear with me. I've kind of got this thing jumping around. I'm done with that.
I know there was a question submitted earlier, Tripp, about, you know, what happens, do we have to be concerned about passengers now that, you know, we've got this no-fault reform? And the rules about where you go in terms of coverage if you're a passenger have changed, but believe it or not, folks, they changed a year ago when this no-fault reform was first enacted. And you still, whether you're a passenger or a driver, you're still always looking first to the group health plan that the person is enrolled in, and whether they're, you know, primary, secondary, et cetera. And then you still are, I believe, looking at the no fault of if that passenger has their own no fault. So you're still looking at those things. And of course, the passenger could always, you know, see if there's any other person in their family member. But there are some rules on that. They have changed a little bit, but the two primary sources of coverage, the person's own no fault and the person's own group health coverage, still will be looked to.
All right, Mary, we got another question that talks about, and a participant is still a little bit confused when we have a plan that pays secondary, how this is not an exclusion, and therefore the plan still pays qualified health coverage. And I would say, you know, then again, this is based on Mary and I's interpretation and our understanding. Right. And the reason is we don't actually have an exclusion like a $250,000 exclusion of benefits in the event of a no-fault accident, or we don't say benefits are completely going to be excluded in the event of no fault. We're just saying we're going to pay after somebody else pays. And if someone elects no medical benefits under their PIP policy, under their no-fault policy, there is no primary payer. So the group health plan is going to step into the primary payer position and pay in its entirety without any exclusions.
Right. To the extent the expenses are eligible, right, under the plan. So, yeah.
Another question, and I think this goes to what you just answered, Mary, are dependents who are not the owner using the vehicle affected by the PIP election made by the owner. And that's, I think, first of all, you have to go through that priority level of which no-fault policy pays first.
Right.
And if you get down to where it's the no-fault policy of the owner and they elected a lower PIP medical benefit premium, then yes, the non-owner occupant or non-owner driver would be subject to that limitation.
Mm-hmm.
Mary, for this very brief second, there are no more Q&A or questions in our online Q&A.
Okay.
So I don't know if you have any more that you wanted to address, or if we got through all those from the pre-registration.
No, I think that we did a pretty good job in the pre-registration. So.
Oh, we got. Let me take one more here. So I think the question here relates to whether I can still buy coordinated or uncoordinated policies. So whether a no-fault policy will pay basically primary regardless of other coverage, or we'll try to coordinate. And I don't think we know of that, but I did talk to another individual who is more familiar with PIP than I am, and he estimates that probably will be available. It'll just be interesting to see what that looks like in terms of a premium differential. And if there's not much of a premium differential, especially with a lower level of PIP, will it technically be possible? Maybe, but it may be not very desirable.
Yep. There were a couple other questions I just want to flag here too. One was, what concerns or changes to our general liability and automobile policy should we consider? And I guess I would say that was really beyond the scope of our webinar today. And then there was another question about, if we have employees that receive car allowances to drive their own personal vehicles for a business purpose, can we impose any rules on them? And I don't see any reason why you couldn't say, gee, a condition of this, car allowance is that you're going to carry at least, $250,000 a PIP or unlimited PIP or whatever.
I agree. I would say your typical employee that is not getting a car allowance. I did get this question: can we force those employees to elect a no-fault policy with a certain PIP coverage level? And my answer to that question was probably not. But of course, you can use one of these plan designs and educate your employees to understand your plan design. And they will, if they're smart, will buy the requisite no-fault policy to avoid a coverage gap. But in the instance where you're providing a car allowance, I don't see a reason why you couldn't condition that car allowance on a certain PIP level.
Absolutely. Yeah. Well, hey, thank you, Tripp, and thank you everyone for joining us today.